Good morning, everyone, and welcome to our webinar on redundancies and restructurings in the HE context. There are still some people coming in, but I'll just do some housekeeping before we start. So today's session is being recorded, and the slides and a link to the recording should be sent to you within the next few days after the session. If you have any technical issues, I've been told the best thing to do is to go out and come back in again. But if you do have any technical issues, other technical issues, then please put those issues in the chat. We also want to encourage you to ask as many questions as you want to ask today and make it as interactive as possible. So please, if you could put your questions in the question and answer section. So to start off, my name is Jane Byford. I'm an employment partner and head of higher education at VWV. And with me today is Katie Hurst, who's a senior associate. She's an employment lawyer who specialises in advising universities. So knows all about these kind of situations in universities. So what we want to do today is really look at some of the tricky issues that are coming up in the restructurings and redundancies that are happening all over the sector at the moment. Most of our university clients are doing some kind of restructuring or redundancy process, even if that is just in relation to VSS schemes at the moment. So what we want to do today is Katie's going to give you a basic overview. Then I'm going to look at the difference between voluntary severance and voluntary redundancy and why that's important. Then Katie and I are both going to look at redundancy and restructuring, and it is quite important the difference between those two things. Restructuring can be redundancy, but not necessarily. Then I will look at selection pools and why that's important, and Katie will then come to look at consultation requirements, both collective and individual. And then I'll briefly look at alternative employment, and hopefully we'll then have plenty of time for questions at the end. So I'll hand you over to Katie.
Thanks, Jane. Good morning, everyone. Thanks for joining us. So today we will look at redundancy and restructuring. As Jane mentioned, what are the differences between those two? Sometimes they are terms used interchangeably, but they're very different things. We will look at the legal framework and legislation around redundancy. So the Employment Rights Act and the definition of redundancy in particular, as well as the Equality Act and the discrimination risks associated with redundancy processes, and also collective redundancies and the consultation requirements. And throughout, we'll look at the key principles of a fair process and what that looks like. So we'll talk through a redundancy process right from the outset all the way through to the end, and we'll touch on all of these issues as we go through. So I'll hand back now to Jane to talk about voluntary severance.
Thank you, Katie. So voluntary severance and voluntary redundancy are sometimes used interchangeably, but they are specific terms, and there are different legal and practical different effects of the two situations. So many universities have been going through voluntary severance schemes, VSSs, recently. Typically, those schemes are open for a period of time, usually offer some kind of enhanced package to encourage people to apply. And it's not necessarily a redundancy situation. It's often used as a way of cutting costs without making redundancies or even considering any compulsory redundancies. And employment usually terminates by mutual agreement rather than it being by redundancy or a dismissal. And usually it doesn't trigger the duty to collectively consult because it's before you're actually considering redundancies. So my top tip with a voluntary severance scheme is make sure that you've got the right to reject applications. You need to ensure that you maintain an efficient workforce following the voluntary severance scheme, and then you're not going to have to then re-employ someone. You pay someone an enhanced package to go and then have to re-employ. If you're paying an enhanced package, I would also say it's important to have a settlement agreement to make sure that no claim can be brought. I have seen cases where even though somebody has volunteered under a voluntary severance scheme, they've then later brought a claim in the employment tribunal. So I'd say a settlement agreement is a good idea. And that's particularly the case where there are pension issues involved, particularly under the LGPS, where if someone over 55 is retiring early on the grounds of redundancy or efficiency, that may trigger a right to an actuarially unreduced pension, which can have a significant pension strain on the university. So you need to make sure that's covered off in a settlement agreement. You need to make sure you consider the potential costs of that in relation to the package that you're offering. Voluntary redundancy is usually much further down a process. It's when an employer or university is considering redundancies, but before it asks for volunteers before going through a selection process. And even though an employee is volunteering to leave, they are actually in this sort of circumstance, because it is a redundancy situation, being dismissed by reason of redundancy. They're a volunteer, but it's in redundancy process. Because it is redundancy, you need to consider carefully whether it triggers collective consultation requirements. So often, usually volunteers for redundancy will be included in the numbers that then form the trigger for collective consultation requirements. And someone who is voluntarily redundant, made voluntarily redundant, usually is entitled to at least their statutory redundancy pay, but you may enhance this to encourage volunteers. Katie, over to you.
Thanks, Jane. So I'm going to look first at the differences between a redundancy and a restructure. So they're two distinct concepts. Sometimes the terms are used interchangeably, but redundancy has a clear statutory definition under the Employment Rights Act, which Jane will come on to in more detail. But essentially, a redundancy will involve a reduction in headcount. So, for example, closing a university course, or requiring less academics to teach a particular course because of a drop in student numbers, for example. Those are the kinds of situations that are likely to fall within that definition of redundancy. There are collective consultation requirements associated with redundancy, depending on the numbers. So 20 or more employees will trigger the collective consultation requirements. And redundancy is a potentially fair reason for dismissal under the Employment Rights Act. And again, if it is a redundancy, an individual is likely to be entitled to a statutory redundancy payment. On the other hand, a restructuring has no formal statutory definition. It can involve a number of changes that don't necessarily result in a reduced headcount. So redundancies can often form part of a bigger restructure, but a restructure in itself doesn't necessarily mean that there will be redundancies. Changes to terms and conditions can fall into the restructure category. So when we talk about changes to terms and conditions, we are talking about the fire and rehire practice. We know following the P&O Ferries case that there's now a code of practice on fire and rehire. And whilst that's outside the scope of what we're talking about today, I just mention it because there are further changes to be made to the ability to terminate and offer re-engagement. So those the date for those changes is yet to be announced by the government, but it's definitely something to be aware of. So restructuring may involve terminations under the some other substantial reason category in the Employment Rights Act. That may happen where the situation that you're dealing with does not amount to a redundancy under the statutory definition. So the key thing is redundancy often means reduction in headcount. and restructure doesn't. So if I can move on to the next slide, Natalie. Thank you. So what is a restructure? So there's no formal definition. It's often a term which is used to encompass making organisational change, improving efficiency. It can include changes to terms and conditions such as working hours, location, duties, etc. It can happen where there are changes to the way that work is carried out, so introducing new technologies, for example. And we've mentioned that restructure can involve fire and rehire, although this will be heavily restricted going forward. So a restructure is often about change to improve business operations, improving things, not necessarily downsizing and cutting roles. However, it's important to remember that if terminations do occur in a restructure, you must consult with employees and the collective consultation obligations can be triggered. So the definition of redundancy under the Trade Union and Labour Relations Act is wider than the definition under the Employment Rights Act. The Trade Union Labour Relations Act is the legislation which requires employers to collectively consult. So it may be that it's not a redundancy situation, but that there is still a requirement to collectively consult. So I'll just touch on when that arises in the context of a restructure. So the statutory definition talks about an employer proposing to dismiss 20 or more employees within a period of 90 days or less. In those circumstances, the collective consultation obligations under the Trade Union Labour Relations Act will be triggered, as well as the duty to notify the Secretary of State. So if an employer is proposing to dismiss between 20 and 99 employees at one establishment, what that means is that the employer must consult with those individuals for a minimum period of 30 days before the first dismissal takes effect. And if there's a proposal to dismiss 100 or more employees, that consultation period must be 45 days as a minimum. Failure to comply with the duty to collectively consult is quite significant. So for each affected employee, they may be entitled to a protective award of up to 90 days pay. And the failure to provide notification to the Secretary of State is a criminal offence, which can result in a fine. So where there's a proposal to change terms of employment and offer re-engagement, those proposed terminations will count as potential redundancies under the Trade Union Labour Relations Act, triggering that duty to collectively consult if you've got 20 or more employees. It's irrelevant for those purposes that the employer is considering, or the employer is going to offer new terms and conditions. That's irrelevant for the purposes of that duty. The difficulty in practice, of course, is that often at the start of these sorts of restructures, you won't know whether individuals are likely to accept changes to terms and conditions, for example. So you may not know necessarily whether that duty is going to be triggered. In light of the penalties for failing to comply with these duties, it's always good practice to assume that that duty could apply where you've got those numbers of individuals involved, so 20 or more, and to start planning your process on the basis that those obligations do apply and that the Secretary of State is notified as well. So moving on from restructures, I'll hand over to Jane to talk about redundancy.
Thanks, Katie. So redundancy is much more clearly defined in law under statute, and really is one of three sort of scenarios. First is a business closure, a university closing completely. A second is a workplace closure. So both of those are usually called disappearing workplace. And a workplace closure could be something like you're closing a particular campus, or perhaps a particular part of a campus, for example, I don't know, a business school or something like that. That could be, or even closing a particular any department really. That would be a disappearing workplace. You're not going to need anyone in that sort of area, either physically or a business area any longer. What's more common, particularly at the moment, is a reduced requirement to carry out work of a particular kind. So you decide that you either require fewer employees to carry out the same kind of work, or that because there's been a reduction in that kind of work, you need fewer people to carry out that work. So that is the disappearing job. And that is a more complex scenario in a lot of ways because it involves selection. You've only got a reduced requirement, so you still require some employees, but not all of those employees that you currently employ. And that would trigger a statutory redundancy payment, provided that somebody has at least 2 years service. Again, that is something that is going to change with the Employment Rights Bill. And if people are likely to get unfair dismissal rights from day one, and that will include redundancy. So even those with less than 2 years service, you will have to treat fairly when it comes to a redundancy situation. So in a redundancy situation, that is going to trigger consultation requirements. Firstly, individual consultation requirements, regardless of how many employees you are proposing to make redundant. And as Katie mentioned, if it's 20 or more employees, it could also trigger the requirement for collective consultation and the requirement to inform the Secretary of State via an HR1 that you are about to make collective redundancies. So if we move on to the next slide and think about formulating a case, business case for redundancy. And this is really important to have a paper trail in place as to the decisions you've made and why you've made those decisions. And if they're ever challenged in an employment tribunal, that's going to be really important to be able to justify your decisions and show why you made the decisions that you made. So I think, first of all, you need to identify the efficiencies you need to make and how those are going to be achieved. That could be financial savings. I know a lot of universities at the moment are looking at, right, we need to cut so many £1 million worth from our staff spend, which means so many full-time equivalent posts, for example. But you may want to just be doing it for operational efficiency, or just to respond to market changes. So maybe you just aren't having as many students applying for particular courses, so it no longer makes sense to run them at all. So you might not just be closing them to save costs, you might have a different demand for those particular courses. And I think you need to define your objectives at the start, and also understand what's at stake. Now, from a legal perspective, that will be unfair dismissal claims, potential discrimination claims, but it's much more than that. As you'll know, as HR professionals, it's things like employee morale and reputational risk. And we have seen a number of universities really quite pilloried in the press about proposals to make redundancies recently. So I think it is something to bear in mind if you are planning a large redundancy programme, that may well be reported quite negatively in the press, and that can then have an effect on your reputation. You'll need to think carefully about how the proposal will achieve your particular goals. Is it going to reduce costs? Is it going to improve productivity? Does it align with your strategic objectives? And really document that process. As I say, that paper trail is really important. Be clear at each of the stages involved, whether it's consultation, selection, final decision-making process. Make sure that it's all supported by a strong business case, and that your decisions can be justified and as being fair if they're challenged. So let's look at running a fair process. And that's absolutely key to avoiding the legal risks, but also reputational risks as well. So you need to consider, first of all, how many employees you're proposing to dismiss. If it's less than 20, then you will have to individually consult. So you need to factor that in to your timeline. If you're thinking of making 20 or more redundancies within a 90-day period, then that is going to trigger collective consultation. And again, when you're putting in place a timeline, you need to take that into account. You need to take, if it's 20 to 99 employees, that's going to be 30 days consultation. So you'll need to factor that into your timeline. And as Katie's already mentioned, 100 or more redundancies, that's going to be a 45-day consultation period. In which you need to consult with the recognised trade unions. And Katie will look at that in a bit more detail later on. But when you're running that fair process, you do need to take into account those issues at an early stage. And also, as I've mentioned previously, your obligation to inform the Secretary of State using the HR1 form. If you are making 20 or more employees redundant, don't forget the individual consultation as well. I don't think it's something you would do, but universities can tend to get bogged down in a lot of consultation with trade unions. That can be quite a difficult process, but mustn't forget that the individual consultation is important to avoid unfair dismissal claims as well. And any consultation, be it collective or with the individuals, should be a two-way process. It is consultation. People should be allowed to express their views, to ask questions, suggest alternatives. The whole idea about consultation is to try and avoid redundancies in the first place, but if not, to avoid some of the impact of those or make the impact less. So consultation must happen before any decisions are actually made, and it's important not to make those decisions before consultation is concluded. Katie.
Thanks, Jane. So how do we mitigate the risks of claims, so unfair dismissal claims, discrimination claims, etc.? Well, we've touched on this point already, but it's all about planning the process really in advance, being very clear about who needs to be informed and what the timescales are. So although there may be those minimum collective consultation periods, you will often build in more time than that into your overall plan because things take longer than expected. Availability for meetings and all of those things can be impacted once you get into these quite detailed processes. So plan in advance. Lots of universities will also carry out an equality impact assessment as part of the sort of planning process. And that will often take into account how it will affect different groups of people. So in terms of discrimination, looking at what the risks are there, sort of mapping out how the groups are made up, etc. So that can be quite a useful tool to use as well. If it's applicable, follow the current statutory code of practice on fire and rehire, although, as I've mentioned before, that's subject to change. Our slides have disappeared, but I'll carry on for the time being. So in terms of timing, those consultation periods are minimum periods. Also, just to mention on collective consultation, lots of universities will in fact collectively consult even where there might not be a statutory obligation to do so. So some of our university clients will do that even if there are less than 20 employees, for example. So again, it's building those timelines in. As lawyers, we always like contemporaneous notes of meetings and for those to be as accurate and detailed as possible. Appreciate that when you're doing lots of these meetings, it can be quite difficult to keep that up, but it's really helpful in terms of risk mitigation that you have an accurate record of what was recorded. What we often see as advisors are disputes around things that were said during consultation. So disputes around what the employee might have suggested, allegations that suggestions weren't considered or taken into account, or that nobody responded on the suggestions, those kind of things. So note taking, whilst it's very commonplace, is really important. Send those notes to people, make sure that they are agreed where possible, and after meetings follow up in writing again to confirm where you're up to, what's being discussed and agreed. The other point to mention is consider offering settlement agreements. So you may be more likely to do this where you're looking at voluntary severance and voluntary redundancy, but consider the use of those potentially more widely, because that, of course, significantly mitigates the risk of future claims. And our slides are back on, just in time for the next one, please, Natalie. Perfect. So what else should we consider in terms of mitigating the risk? So a bit of an obvious point, this one, but choose non-discriminatory selection criteria. So things that directly discriminate on the grounds of any of the protected characteristics are going to present a large amount of risk. I mentioned the protected characteristics, but also criteria which discriminate on the grounds of being a fixed term or part-time worker are also potentially discriminatory. So it's important to think about how the criteria applies to the groups of individuals potentially at risk. Criteria that have an indirect effect can also potentially be discriminatory. So, for example, a criteria that affects a particular group of individuals, so particularly affects women, for example, or particularly affects employees of a certain age, are potentially discriminatory as well. So often universities will have criteria that they use whenever redundancy situations arise, but it's important to keep those under review. It should always be objective, so skills, experience, performance, etc. are always the preferred sorts of criteria. So I'm going to mention pregnancy and maternity leave in particular. It's a tricky area under redundancy. We get lots of queries around pregnancy and maternity leave from our clients who are going through redundancy processes. So employees who are pregnant or on maternity leave have special protection under the Equality Act. Of course, they can't be selected on the basis that they are pregnant or on maternity leave. And anyone, I suppose the golden rule is anyone who is pregnant or on maternity leave or has recently come back from maternity leave is always an individual to look at carefully in terms of the process and how to manage it and the risks associated with that. Going to just mention the special treatment of a woman in connection to pregnancy, childbirth or maternity. So the Equality Act says that special treatment afforded to a woman in connection with pregnancy, childbirth or maternity must be disregarded for the purposes of direct discrimination. And what that means in practice is that a male employee can't claim that he suffered sex discrimination because he's not been afforded the same special treatment. However, a note of caution on the special treatment, quite a well publicised case that we've got on the slide, Eversheds and DeBellin. In that case, the outcome was that it was found to be sex discrimination against a male lawyer who was made redundant when his employer artificially inflated the scores of a female colleague on maternity leave. So there is a delicate balance in terms of the protection that is offered to women on maternity leave. However, women on maternity leave and new mothers should be given first refusal in respect of alternative employment. So this is a duty to be offered a suitable alternative vacancy where such a vacancy exists. It is not a requirement to create a role. It is only a requirement to offer what might be available. So if a redundancy situation arises during maternity leave and it's not practical by reason of redundancy to continue to employ that individual under their existing contract, they are entitled to be offered a suitable alternative vacancy. Now that's right to suitable alternative vacancies arises during maternity leave. Since the 6th of April last year, that right also applies during the protected period of pregnancy. So from the point that an individual notifies their employer of their pregnancy, that protection and the right to suitable alternative employment also applies. Also, since the 6th of April last year, there is an additional protected period which runs from the return of the individual to the workplace. In total, that's a period of 18 months after the date of the child's birth. So it's quite a significant period now that protection applies. And also the final note on protection there is that from the 6th of April this year, the same applies during a period of neonatal care leave. And then I'm going to hand over to Jane to talk about selection pools.
Okay, so the next step practically is to look at selection pools, and I'm going to look at these various questions, what you should be looking at, and what a selection pool is, and how you should approach it, and the considerations you should be thinking about. So if we move on to the next slide, let's start off with what a selection pool is. Well, in a redundancy situation, the selection pool is that group of employees who you're considering being made redundant. It's typically a group of people performing similar roles or who have interchangeable skills. And an employer has quite a discretion as to selection pools and how it forms those selection pools, but it does need to be make sure that it does so fairly and they can justify why it used a particular pool. So you can't just put a group of troublesome employees in a pool and say we want to select from those people. You need to have a reason why you're using a particular selection pool. You need to define that selection pool using fair and objective criteria, and select employees from within that pool. And if you do that, hopefully you'll avoid claims for unfair dismissal. But that's a key point. It needs to be fair and objective in relation to the criteria you're going to use and the pool that you are using, and make sure that you're treating employees equally and that the selection process is transparent. So deciding on the selection pool in the first place, well, that's identifying which employees are at risk of redundancy. And there are various ways that you can do it. There's no right or wrong way. You just have to be reasonable and fair in the way that you do it. So you may have employees who are all doing the same roles or very similar roles, and you put them into a selection pool. You may go wider and have a selection pool based on employees who have interchangeable skills. So that may be across particular teams or particular departments. If you think you have particular roles or which engage particular skills that are much wider than just one particular team or one particular department, you can go across and use the interchangeable skills way of making a selection pool. And you do need to consider also the impact that the restructuring may have on different teams. So if you're going to particularly use the interchangeable skills, think more widely about what impact that's going to have. And the potential risks of incorrectly identifying a selection pool are that basically unfair dismissal claims, but also potentially discrimination claims if you've used a discriminatory selection pool. The key is, I think, not to define a selection pool too broadly or too narrowly. You need to be reasonable and certainly be able to justify, and as Katie said, that paper trail, those notes, why you made the decisions, why you decided on that particular selection pool are going to be very useful if you do end up in employment tribunal. It's also incredibly important not to predetermine who's going to be made redundant. Those employees within that selection pool, you make the decision on the selection pool first, and then you apply selection criteria. You'll undermine the whole process entirely if before any consultation or selection takes place, you've predetermined who will be made redundant. So common approaches to selection pools. As I've said, there are various ways of doing it, and you need to choose one that's appropriate for your university. So job-based selection pools, as I said, based on the specific role they occupy. For example, you may have a secretarial role in a particular department, so all the secretaries in that department go. You may have lecturers who are teaching modern languages, for example. So they're all in the same selection pool. You may have team-based selection pools or go wider on department selection pools. Look at the whole department, even if their jobs differ slightly. What do you want to end up at the end of the redundancy or restructuring exercise with? So have a wider pool there. As I say, you may have skills-based pools, they may be wider, or you may go beyond departments with those. So look across the university at what you need based on the skills that you need. Sometimes there will be a single employee redundancy. There's only one person occupying a role. If you're going to go down that route, I just say just be very careful and make sure you can justify that decision and it doesn't look like you're just singling somebody out. But particularly in more senior roles, a single employee redundancy is often justifiable. You just need to be very careful that you can justify that approach. Whatever kind of selection pool you're going to use, then just to ensure you're transparent about it, you consult with the employees and the trade unions on those selection pools, and that you avoid any discriminatory or subjective decisions, and make sure you keep a record of why those decisions are made. Katie.
Thanks, Jane. So we'll look again in a little bit more detail on the consultation requirements. So if we can just go on to the next slide. So what are the legal obligations? What are the two different types? And importantly, what is the purpose? So there will always be a duty to individually consult, as Jane has mentioned. There may be a duty to collectively consult. And as a university, even if there isn't a duty to collectively consult, it may be common practice that the university does that. So the purpose of consultation is, well, several reasons really: ensuring that there's a fair process, exploring alternatives to redundancy, and mitigating the impact. So really looking to avoid making redundancies is the aim. So I can move on to collective consultation. So we've talked about this. So 20 or more redundancies in a single establishment within 90 days. So it can be that, in fact, you have an initial proposal which involves 10 employees, for example, and 30 days later, you have a further proposal at the same establishment for another 10 employees. When you aggregate those redundancies, that would trigger the duty to collectively consult. So you have to be very mindful as you go through these processes that actually that duty may be triggered at some point along the line, even if not initially. They are minimum consultation periods. You can build in longer to your timetable for these things. Often in practice, they take longer than you think. And as James mentioned, consultation must begin before final decisions are made. Involvement of trade unions. You will have recognised trade unions for the majority of your employees. There may be cases where you have certain groups who are affected for whom a trade union is not recognised. So you would need to think about whether employee representatives need to be elected specifically in respect of that group of individuals. Or it may be that they are included as part of the process with the already recognised unions. But again, these are conversations to be had. The key point being that those individuals are also represented in that collective consultation process and have a representative who they can go to and discuss things with. And we've mentioned already the requirement to notify the Secretary of State if collective consultation does apply. And again, keeping that under review as you go through a process in case it crops up at some point. So the goal is to allow employees to have their say. It should be a two-way process. We should look at exploring alternatives, and all consultation should be conducted in good faith. So again, that conclusions are not made prior to those processes. Individual consultation, which will always be required for redundancies. So some key steps that we've set out on the slide. So inform the employee that they're at risk, provide the reasons for them being at risk, explain the rationale and the criteria, the selection criteria that are being used, how that selection process will work. Often employees will ask questions around the selection process. So whether that be around the criteria or the individual that will be carrying out the scoring. Sometimes we have queries in relation to the fairness of that, particularly if there has been an issue between the individual and the person carrying out the scoring. So think carefully about ensuring that that's an objective process. Again, consider alternatives and allow sufficient time. And importantly, always provide a right of appeal against any decision to dismiss on the grounds of redundancy, because failure to do so presents an unfair dismissal risk and also a potential uplift to compensation for failing to follow that fair process. So I'll hand back to Jane to talk about alternative employment.
Okay. There is no statutory obligation to search for suitable alternative employment, but it's made clear in case law, very well established, that you do have a duty to make a reasonable search for suitable alternative employment. Now, in redundancy situations where that we're dealing with at the moment, there may not be suitable alternative employment, but you need to demonstrate at least that you've looked for it. So basically it means you should be consider matching vacant roles to those employees who are suitably who are potentially redundant. So you're not obliged to create new roles for them where no role already exists. But if you do have vacancies and you have employees who are going to be made redundant otherwise, who may be suitable for those vacancies, you need to consider that as a way of avoiding redundancies. And if you don't, that's likely to be an unfair dismissal. So where you've got more than one potentially redundant employee, you may need to make a selection between employees. And if you're doing that, you need to make sure that all employees are aware of vacancies and that who you choose for the alternative employment, the way you do that is done in a fair way. That may be using selection criteria, so selecting in, it may be via interviews. But you need to make an objective assessment of whether the alternative employment is suitable for the employee. And that has, and you look at the nature of the role, so things like the status, the terms, the salary, the hours, the location, and things like that. And is it a match for the employee? But if an employee unreasonably refuses an offer of suitable alternative employment, then they could lose their right to a statutory redundancy payment. And the reasonableness of refusal is based on the employee's subjective reasons for rejecting it. So that can include personal circumstances. So if an employee says, well, I can't work at that other campus because of my childcare commitments, even though their contract might say that they are required to work at any campus, then that may well be a reasonable refusal. So the employee may still be entitled to a statutory redundancy payment. But if a role is really suitable and an employee can't come up with a reason why in their personal circumstances it's reasonable to reject, then that could result in them not being entitled to statutory redundancy payment. So employees being offered suitable alternative employment are entitled to a statutory trial period of 4 weeks. That's for both sides to assess the suitability of the alternative employment for the employee. If it's successful, the employee continues. If it is unsuccessful, the employee will be dismissed. Another issue to think about in relation to alternative employment is to think about your redeployment policies and procedures, which may result in some kind of salary protection for a period. If someone accepts a job that is perhaps on a lower grade with a lower salary, their salary might be protected for a particular period. So that is, I think, all we wanted to say about about redundancy and restructuring today. But we have had a number of questions, and please do continue to put them in there. I'll take the first one, Katie. It says, if a VS scheme has been implemented without settlement agreements, what is the impact? Sorry, can you still pay out the amounts? In this case, they've had the pension strain as well. So I'm assuming this is under the LGPS. So I would say if you're paying more than you are obliged to do under contract and under statute, that a settlement agreement is always a good way of really setting out what you're paying, why you're paying it, and the tax treatment of that payment as well. Particularly when you do have a strain payment under the LGPS, it can also make it very clear how you've treated that. You may have reduced, for example, a voluntary severance payment by the amount of the pension strain. And if you set that out clear in a settlement agreement, that will prevent the employee bringing any claim in relation to that. The fact you haven't got a settlement agreement doesn't mean that you can't make the payments. Or anything like that. It just means that you are at risk of a claim, and also that if you haven't set out somewhere full details of exactly what you've done and why you've done it, it may be difficult for you to justify the decisions going forward. Katie, are you able to pick up the next one?
Yes. So the next question is, where you submit your HR1 at the start of your consultation, but the numbers of redundancies change during consultation, are you obliged to submit a further HR1 before the outcome of consultation is shared? I think it depends what we mean by change in numbers, but I think the answer to that is probably yes. So you submit a HR1 at the start because you think you've got 20 or more individuals at risk. And then at some point later, if you have a further set of individuals potentially at risk, and that triggers again the collective consultation duty, you would have to submit another HR1. I think if your numbers went down, there wouldn't be an obligation to submit any further form unless you have a different view on that, Jane.
No, I think the key is if you say you've got 20 to 99, say you've got 98 redundancies you're expecting, and then you've got a trigger that takes you over the 99, that takes you to 100. Yes, I think you do need to then do it in form. Then, because the idea basically with the Secretary of State and the HR1 is just so that in that particular region, the Secretary of State is aware of what redundancies are like to be made, so any measures can be put in place. But yeah, I'd say if you're going over the next trigger point, then yes, update the HR1. So
Okay, the next one is, can you say more about an SOSR dismissal under a restructure and perhaps provide an example? Not sure if an example is the fire and rehire scenario. I never have a good example for this. I don't know if Jane does, but the fire and rehire scenario does potentially fall within that SOSR dismissal. Don't know
you
if you
do
have.
sometimes have a restructuring that actually isn't going to involve any redundancies. You just decide that actually the structure you've got in a particular department, say, or a particular team, isn't what you need going forward. So you decide that you need to reorganise roles so that different roles are being done by different people. You separate the roles out differently. So you still need the same number of employees, but just what they're doing is different. And sometimes in those scenarios, you'll sort of ring fence the people who can apply for the jobs. So you're still going to keep your employees. The jobs are just changing a bit without the hire and refire usually. So it's just shuffling the work around. That could be a restructure, for example. I don't know if you could think of anything else, Casey.
No, I think that's a good example. Just looking at the next one. So what's your recommendation for managing the risk with regards to colleagues that are struggling with their mental health due to finding the process stressful and will not engage with consultation with regards to restructure and redundancy? This has cropped up quite a few times recently, I think, in our advisory work. It is difficult because with mental health, that may mean that the individual has a disability and you need to be mindful of your obligations under the Equality Act. What we have talked to clients about recently is trying to engage with people in writing. So whilst that isn't ideal, if you've got an individual who is finding it very stressful, doesn't want to attend meetings, or is perhaps finding it difficult to process information that's being given to them, sometimes inviting them to put their thoughts in writing can be helpful, and responding in writing as well. There's a balance, isn't there? Because you want to encourage people to actively participate in that process, but without sort of worsening their health. Don't know if you've anything to add to that, Jane.
No, I think that's just very, very sensible. I mean, if you've tried to consult and you can't consult, just make sure you've got everything in writing and do all you can, really. And it is often a very stressful situation. And on the one hand, the consultation is there and having to have individual consultation and reasonable periods of consultation, a reasonable length of time. On the other hand, that can just prolong the agony for some people who prefer it just to be over and done with quickly. But you just got to demonstrate, I think, you've done the best you can. So the next one is an example of 10 redundancies and a further 10. Does that trigger longer consultation requirements? Would you go back to the first 10 and effectively consult, or would you just do it going forward? And the same applies to the HR1. Casey, I don't know whether you got any thoughts on this, but my thoughts are no, you don't go back to the original 10. You just start the collective consultation with the next 10. And this often does happen, and it's a question of timing, really, that during a process, originally, yeah, you want 10, and then actually you think, well, now we want to restructure a different department, that's another 10, and it's within the 90 days. So that triggers the collective consultation requirement. For that second 10, you don't have to go back to the previous 10. But again, with the HR1, again, it would trigger, the second 10 would trigger the HR1 requirement. Katie, anything?
Yeah, no, I agree with that. And like you say, it does crop up sometimes as you go through these processes.
Okay.
The next one is a ring-fence interview a fair selection process to determine who should secure a role within the structure, leaving the unsuccessful candidate at risk of potential redundancy? So can you ring fence interviews is the question, I think.
I think yes, you can if you've got a number of employees who are in a selection pool. So you're going down, say, from 10 employees to 6 employees for a particular role. Yeah, it's quite usual to ring fence and have interviews as part of the selection process. You may not have that. You may be able to do the selection process on paper, depending on what your selection criteria are. But I think that's a sensible way of proceeding, and it often does happen within universities.
Yeah. Okay, the next one, is there a maximum period for a trial period?
The statutory period is 4 weeks. I have seen longer periods used, but that's not within the statutory scheme then. That would be something different. So the statutory scheme is just the 4 weeks.
Okay, the next one is, does a pregnant employee or employee on maternity leave have priority over other employees in relation to redeployment over and above employees with other protected characteristics, such as disabilities? It's a difficult question. Yes, I think is the answer. If there is a suitable alternative vacancy which arises during that period that the pregnant employee is protected, then they have the preferential right. That's not to say there isn't a risk as regards other individuals who might have disabilities, etc. But there's no, for example, there's no reciprocal right under the Equality Act for an individual with a disability to be offered suitable alternative employment on the basis that they have a disability. But it's going to be very fact specific. Do you agree with that, Jane?
I think that's right. I mean, this is a statutory right. So I think women who are protected under the maternity regulations are they come first, and then someone perhaps with a disability or another protected characteristic you might want to consider after the women who are protected due to pregnancy or maternity. I think that's right because it's a statutory right. Next one. Are colleagues returning from adoption leave protected in the same way as maternity leave? The simple answer is yes to that, isn't it, Katie?
Yes.
Right, going back to the SOSR question, it's not clear from the example given where the job loss would be. You would have, sorry, I can't read that. Would have to have the same headcount. Still not clear what SOR if it's not redundancy. So I think what we're saying with there's no loss of headcount necessarily in a restructuring situation. A restructuring situation is just restructuring what you need. So altering job roles or looking at the department overall, what you need going forward. It doesn't necessarily result in any redundancies or any loss in headcount. If it does result in redundancies, it's a redundancy, but it could be restructuring and a redundancy. What's important is to make the distinction. Restructuring can be a redundancy situation, but restructuring, a dismissal for restructuring may not necessarily be a redundancy situation, and a restructuring situation doesn't necessarily involve that loss of headcount. Like Katie was given with the example of change to terms and conditions of employment, if you go down, that might result in some people leaving an organisation because they won't accept new terms and conditions. So in the example I was given, if you restructure how a team is running or a department is running, and there aren't any loss of roles in the new structure, but someone doesn't accept through consultation, they don't voluntarily accept the new structure, and then you go down the change in terms and conditions and they don't accept the new role, their role would disappear, but it wouldn't necessarily be redundant. It would be for some other substantial reason because they haven't accepted the new role, rather than there being any loss in headcount. Katie, can you explain that any better?
Yeah, well, I was just going to say, because it doesn't meet the statutory definition of redundancy. That's the key, really, because you're proposing to change terms and offer new terms. You're not proposing a workplace closure, a business closure, or a reduction in headcount. So it is a difficult question, but yeah, essentially there's a difference between how you look at it. And I think your starting point would be look at whether it meets the definition of redundancy. And if it doesn't, then it's not going to fall into the Employment Rights Act redundancy definition. But do drop us a note if that's not clear, and we'll try and go back over it.
When a restructure leads to staff displacement and there are fixed term contracts ending independently of the restructure, how should the situation be managed in relation to the priority groups? My view is if you've got you need to look at why the fixed term contract is coming to an end. It's just not being renewed because if it's, for example, because funding for that fixed term contract, external funding has expired, then that's not necessarily part of the redundancy, the restructuring or whatever. But those people may need to be taken into account if because actually their employment will be terminated by reason of redundancy because you've lost the funding. So they will be needed to be taken into account in collective consultation, potentially, if it all falls within the same 90 days.
Yeah, I'm conscious we're just past 12 o'clock. We've got a couple more questions, Jane, which we can carry on.
I think we'll probably ought to finish now. Please do contact us. Those people who've got the extra questions, please do contact us, or anybody else, please contact us if you have any further questions arising about what we've talked about today. Finally, there's a feedback poll. It'd be grateful if you could respond to that. And thank you very much all for attending. And I hope you found that a useful session. Thank you.